Hi again, Attorney Steve Vondran here, business and real estate lawyer, licensed practice law in California and Arizona. We are talking today about California Rule of Court 3.1113. This is a rule of court that deals with filing motions, how many pages you can have as a max, the things you need to attach, things you need to be aware of, so forth and so on. So let's go now to the real estate whiteboard. Okay, we are talking California Rule of Court 3.113, all right? And we have talked previously, this is when you're in a lawsuit and you want to file a motion. A motion is asking the court to do something. You know, hey, I want to file a motion to compel arbitration. I want to file a motion for sanctions. I want to file a motion for this. I want to file a motion for that. Asking the court to do something when you can't get another party to the lawsuit to agree to stipulate to what you want to do. So that's where motion comes into play. This is what we call law in motion. This is when attorneys go, oh, I was in court today. This is what they're referring to, arguing these motions. So this is a good part of what a lawyer does, is putting these motions together, filing them with the court and the other parties, and going and arguing the merits of the motion, okay? So we talked earlier in another Attorney Steve video about CCP 1005. Write that down. If you're trying to get the time frames for filing your motions, you're going to want to write that down. CCP 1005, Attorney Steve, and you'll get the video. That tells you how many days do you need to file, advance notice, those kinds of things, because you have to give your other party notice. You can't just go in there and file a court. But check that out, CCP 1005, Attorney Steve. That video should hopefully come up. Now, we are talking California Rules of Court 3.113. Sometimes parties want to know, well, when I write a motion, what am I doing? What do I include? How does it work? Okay, well, that's a good question. So basically, you're going to file a motion. You're going to file a notice and a motion. So a notice of motion and a motion, and you'll also have excuse me, you'll also have your memorandum of points and authorities, your facts and your law and the things that you're relying on, and you may have some documents that you attach to your motion so that you have some other things to show the court. You may have case law that you're citing in a separate authority. You may have declarations of your lawyer or of the plaintiff or the defendant. You may have declarations, or you may have declarations of third parties. That's possible. And you may have requests for judicial notice. And we're going to talk about that in another video. But a request for judicial notice is asking the court to take notice and consider as evidence certain different things, like things that are beyond dispute, like the earth is round, asking the court to take judicial notice of certain things. That's governed by another rule of court, 3.1306, subsection C, as in Charlie, and we'll talk about that in another video. But these are the types of things you may be attaching to your motion, your notice of motion and your motion, okay? So the California Rule of Court applies in your California courts. This is 3.1113. You're going to file your notice of motion and your motion. Now, in most cases, that would be put in the same document. You would put your notice of motion, and then you would just continue on with your motion, your memorandum of law and authority, and those kinds of things. So bear that in mind. Now, your judge may have some special rules. You don't know. You need to always check with your local rules, your courts, your things like that. See if you have any special requirements. These are your general California Rules of Court, okay? So you have your notice of motion. Your notice of motion is just saying, you know, on this date, I'm coming forward. You have a date that you've secured with the court clerk, and you are going to have a motion on this day, and you're giving the other parties notice of your motion. On this day, they will be moving the court for a motion to compel arbitration, blah, 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 you know, and I like to make sure I'm always requesting oral argument in these motions, because sometimes for example, in federal court, the judge may determine a motion without any hearing whatsoever. So I always like to at least request it so that I at least have an opportunity to present any oral argument that the judge may allow. So anyway, so what goes in the motion? You got the notice of motion, and then you have your motion. Your motion is basically a memorandum of points and authorities. Memorandum of points and authorities. You're going to have your facts. Here's what happened. You may start with an introduction or a summary of your argument. That may be something you want to do, a nice, short, concise statement of what's going on. But get your facts in there. Any procedural history that might help the judge, that's also important. You know, the lawsuit was filed on this date, you know, we moved here, they did this, now we're here. So facts, any procedural history, and then your law, your memorandum of points and authorities. Normally you have to have some law that the judge can hang his or her hat on in order to find in your favor. In other words, if you're just saying, hey judge, you should do this, I think it's a neat thing to do, that may work, but what law is, it's a game of law. It's a rule, it's the rule of law. So you want to be citing your case law using the proper citation format, and we'll talk about that in other videos. We don't have time right now. But you're going to cite your law, the reasons why your facts are similar to the facts of this case that you're citing, making that case legal precedent, stare decisis as we call it, mandating that the judge follow this law. That's what you're trying to do, is find those key cases that you can cite to the judge that will tell the judge this is what needs to be done. It allows you to argue your points, okay? So your facts, your procedures, your law, and your arguments, your legal arguments. Now, finally, when you're doing a motion, you're also entitled to try to provide some other materials that the court can consider in trying to rule on the motion. I mean, for example, you may want to provide some case law authority. You may want to say, here's a case out of jurisdiction, or here's a newly published case, and I want you to take the court to take special notice of that. You can do a special notice of a case. You can do declarations. What's a declaration? That's a party or a non-party that's making statements based on personal knowledge under penalty of perjury, basically explaining their version of the facts and asking the court to consider it as evidence. So you have declarations, and we'll talk about those in other videos. What is a good declaration? How do you want to do it? And you may want to have requests for judicial notice, which is different things that you may ask the court to consider as evidence, usually things that are so reliable and so well known to be true that their authenticity and the evidentiary value cannot be reasonably disputed. So, and there's a whole types of lists of things that can be done, treatises and things that are common and ordinary, and we'll go over that list. So those are the types of things that you want to do with your motion. So you get your timing under CCP 1005, you get your court date. There's a couple other little housekeeping items to keep in mind when you're doing a motion. Some people may say, well, I want to put a 100-page motion out there. I have so much to say, this, that, and the other. Your motions are generally limited to 15 pages, okay? Generally limited to 15 pages. You get more leeway if it's a motion for summary judgment. You're going to get more leeway, and you can also petition the court. As California Rule of Court 3.113 says, you can petition the court with 24-hour notice seeking longer briefs, longer memorandum, okay? So if you really just can't say it in 15 pages, which realistically you should be able to condense your argument and your law into 15 pages if you do it right, you can always go and ask the court for more. And the court may say fine if you have a good reason, and you could be denied if it's just no. So my thing is, I always try to be succinct, not talk too much, say the points, get in, get out. The judge is very busy and courts are overloaded, so get in and get out, say what you need to say, as John Mayer would say what you need to say. Okay, and then basically if you exceed the page limit maximum under CRC 3.1113, the court can treat your materials as late, give it the weight it wants. So you run into some jeopardy if you're trying to get too long-winded on your arguments. So keep it short, keep it within your page limits. Also realize one other tiny little rule that a lot of people forget is if you go over 10 pages, if you're between the 10 and the 15, you want to make sure you have a table of contents and a table of authorities. Okay, now you don't number these are unnumbered pages. Usually just little Roman numeral is fine, but you're going to want a table of contents which lays out what your argument is. Just a table of contents, just like in a book. Okay, so you're going to have your table of contents and you're going to have your table of authorities. What's your table of authorities? Well, when you're citing the law, remember I said you're going to cite the case law? When you're citing your law, you have a bunch of cases that you're citing. The table of authorities is nothing more than a list of your cases, and it points to where in your brief the judge can find that case. Like if it's Gomes versus Countrywide on page 8, you're going to put in your table of authorities Gomes versus Countrywide, page 8. That's where you can find it, Your Honor. If you're looking, the judge is looking for the cases, you can go right there and find it. The same thing that you want to do with your authority that you're citing, your other evidence that you're submitting, cite exactly to the page where the judge can find it. Okay, you're always trying to make sure that the judge knows where to find it, or the judge's clerk, so it doesn't take forever to pinpoint what your arguments are. The judge may just want to focus on a particular point that you're making, and they need to be able to easily reference. Okay, so that's what you're doing. You're always referencing these things, incorporating these documents by reference into your argument, citing to them, and that's how you do it. Okay, that's basically your law in motion. That's filing a notice of motion. And this is a lot of what we do as attorneys, is get these things filed and make a compelling argument that the judge should do what you're asking the judge to do as a matter of law, that this is what the law is. Okay, so this is it. This is Attorney Steve Vondran. If you need a business and real estate lawyer, find yourself in a state or federal lawsuit, find yourself in arbitration, mediation, you need a good attorney on your side, give us a call, 877-276-5084. And we thank you for listening to Attorney Steve and the Attorney Steve Whiteboard. We'll see you again. Have a great week. Best of luck.